Okay, so while we're waiting for Ebenezer, today I want to speak on there are technical law reform is a technical area of law. If you don't know
Mm-hmm.
it, you will mess it up. Those of you, there's someone here from Zamfara State. I can tell you because I've been involved in law reform projects. I was a consultant to the Nigerian Law Reform Commission, Abuja. We started the process of review of the LFM, that is Laws of the Federation 2004. Then it was 2014 version we were doing. So law reform is a very technical area. It's not everybody that knows it. So if you take time and know it, you will be engaged by governments, ministries of justice to carry out their law reform projects. So you need to know the technical details of what is involved. Now, there's a difference between law reform and law revision, and even the word law review. You should look at these terms. You should know. I've posted on the uh, group. If you're on the group chat, you will see all that I've posted. These are articles. One of them is by a Kenyan lawyer. We did PhD together at the University of London. In fact, he's now the head of legal department, Senate of Kenya, the Parliament of Kenya. Then he was the head of the Law Reform Commission of Kenya. So he wrote a very nice article on law reform. How to define what is law reform. People think, oh, because I'm a lawyer, I'll just get up, I'll do law reform. No, it doesn't work that way. So let me give you examples. The word law reform is different from the word law review. It's also different from the word law revision. These are different activities performed by the Law Reform Commission. I am here in Lesotho after I finished the training of the Office of Parliamentary Counsel. I trained them in legislative drafting. The Law Reform Commission of Lesotho engaged my services because it's a technical area. So the word law review is a preliminary step. Just you want to look at the law to identify areas that need either revision or reform. Notice these two words. Law revision is different from law reform, but law review is just the preliminary step to identify the areas in your law, the laws of any country, the laws of any states that require either law reform or law revision. I'm using these two words. They are not interchangeable. They are different. Law reform is different. Law review is different. But people mix them up. Lawyers mix them up because they do not know the technical differences. Remember when we said this course is about changing you, elevating you from being a mechanic to an automobile engineer. Automobile engineer and mechanic, both of them can repair cars. But the difference is that one has or possesses technical professional knowledge. That is the engineer. But the mechanic just has trial and error knowledge. He doesn't know the inner workings of an engine. So when it comes to law reform, the technical word, there's law reform, there's law revision. Law review is a preliminary step. Oh, let's see. Let's review the laws of Lesotho. Let's review the laws of Nigeria to know whether there's any area that requires revision or reform. So in Zamfara, for example, which was carved out of Sokoto State, I served my youth service in Sokoto State. Just as in the Federal Capital Territory, when a new state is carved out, they use the laws of the mother states. So in the FCT, they use the 1976 laws of Niger State, because Niger State is the major state from which Federal Capital Territory was carved out. Now, if you want to review the laws of the FCT, you look at those laws of FCT that are taken from Niger State that apply, and you now say, okay, this one needs revision, this one needs reform, and I'll tell you the difference. In the technical sense, law revision happens every 5 years. Every 5 years, you revise the laws of a country. That's why we have Laws of the Federation, Revised Edition 2010. That is a revised edition. Revision is different from law reform. The major difference between law revision and law reform is that law reform, the product of law reform activity, has to be approved by the legislature. After you've done all the reform of the laws, you submit it to the legislature. They have to pass a bill to give effect to all that you have reformed. Law reform requires or involves a substantive change to the substance of the law. Words are added. Yes, come in. In law reform, words are added. The substance of the law is changed. But in law revision, you do not touch the substance of the law. You only do clean up, paragraphing, style, presentation of format, arrangement of index. That exercise is called law revision. You number the laws, you arrange them well. You have not touched the substance of the law. That is called law revision. But any activity where you touch the substance of the law by adding a comma, by adding a full stop, by adding some sentences, that is law reform. And law reform happens every 10 years. Ideally, the laws of every country is reformed every 10 years. Then they are revised every 5 years. Ideally, that's how laws are kept in good condition. That's what we inherited from the British Commonwealth. Every 5 years, you do law revision to keep the statute book in neat order. You arrange, if there are new laws, you number them, you create an index. That is called law revision. You do not touch the substance of the law. But law reform requires changing the format of the law. Maybe there were some misadded. Once you have added any word, that is law reform. And when you have added those words, you now take that new addition, the new law you have drafted, bill, you take it to the National Assembly, the legislature. They have to give their endorsement before that will now become a law. That is called law reform. Ideally, every 10 years, the law books of every country needs to be reformed. When I use the word ideally, we don't live in an ideal situation. So in African countries, they don't keep to this. The Nigerian laws, the last edition we have, the revised edition, is 2010. Till today, we do not have, ideally every 10 years, we should do law reform. The money that was budgeted in 2014 for another edition of Laws of the Federation of Nigeria, the Senate Committee on Public Accounts invited Nigerian Law Reform Commission to explain how over 900 million spent on that exercise. We didn't print copies of those laws. That money was eaten just like that. So that's why we do not have a 2014 version of laws of the Federation, because every 10 years we are supposed to have a laws of the Federation, which is law reform. Every 5 years you can do revision. Revision of the law means you do the index, you tidy up the laws without touching the substance. In the last edition, the last time Nigeria did any law reform was Laws of the Federation 2004. In that set of laws, we have 552 laws. Now, after this is where you know the difference between a professional. The Attorney General set up a committee for law reform of the 1990 edition of Laws of the Federation. They finished their job in 2003. They went to LexisNexis. They printed copies of Laws of the Federation 2004. Olisa Bakuba went to court and said, you cannot be citing this 2004 edition. You need to cite the 1990 edition. The court said, yes, he's right. Because after the Attorney General of the Federation, the then Attorney General, after you've done the law reform of the 1990 edition, you were supposed to submit a copy to the National Assembly for enactment, because there were substantive changes to the substance of the laws. So it was in 2007 that the National Assembly passed a law. The law is just one page, a very simple law, a bill for an act to enable effect to be given to Laws of the Federation 2004. That's just the title of that law. That's the body of the law. That is it. The 2004 edition of the laws attached to this law as a schedule to the law. That's it. A one-page law. So, and let me tell you, the composition of the committee set up by the Attorney General of the Federation, it included a professor of legislative drafting, National Institute for National Nigerian Institute of Advanced Legal Studies. This, when we started this lecture, Ebenezer, we were saying some lecturers hoard knowledge. He was my supervisor. I didn't know he had a UNDP project. He now gave me as my LLM dissertation to go and write on that. He was using it for his UNDP. But he had this way of just hoarding the knowledge. So when they set up that committee, he did it by himself, him and the AGF. But Olisa Bakuba sued them to court, and the court said, no, after a law reform exercise, the documents ought to be submitted to the National Assembly. The legislature needs to stamp the approval. Do you know the reason why? Only the legislature has power to add or change anything in a law. So if the Law Reform Commission has done it on their behalf, they need to take it to the legislature for their stamp of approval. That's what law reform. That's law reform. But law revision does not require the endorsement, the stamp of the parliament or legislature. Law revision, because you are not touching the substance of the law, you are only creating an index, you're only making the statute books to be tidy. That one does not require the approval of the legislature. So any law reform agency of the country can carry out that activity. And ideally, it is supposed to happen every 5 years. Every 5 years, you keep your statute books in order, tidy order. Because every 5 years, within 5 years, new laws have come up. So you need to add them to the list, the index of laws of that country. So these are technical things that if you're not a lawyer, you will not know. If you are not an expert in legislative drafting and law reform, check the platforms. You will see the papers on law reform, law revision. These are technical concepts. You can't, another word which, if you read the materials, Ebenezer talked of it yesterday, consolidation. Consolidation is also a technical activity which the law reform agency of any country would carry out. Consolidation means bringing together all the laws on a subject matter. The reason is, for example, investors want to come to your country. They want to know what are the laws on taxation, company income tax, personnel income tax, petroleum tax, all kinds of tax. So the law reform agency of any country would do a consolidation exercise, which is they bring all the laws together, bind them, all the laws on a subject matter, you bring them together. That's consolidation. It helps to keep the books tidy. Then somebody can say, oh, I need the laws on taxation. I need the laws on companies. Everything is in one volume. They can have access to it. Another word is codification. It's another technical word. Codification is technical because codification means taking customary laws, which are mostly oral, but they have, maybe some of them have been judicially noticed by the courts, especially the Supreme Court. Any tradition, any customary law that has received judicial notice by the Supreme Court. Codification is an exercise where the Law Reform Commission of any country will sit down and say, we are going to codify all the laws on marriage in Benin land based on the judgments of the Supreme Court. Now, you take the judgments of the Supreme Court, but the Law Reform Commission cannot give that to the National Assembly or legislature like that. They need to transcribe it. It's called restatement. The technical word is called restatement. So you take a judgment of the Supreme Court, you restate it as a law, and you submit it to the legislature. After codification, the last point is the law reform agency should submit it to the legislature. Legislature will now endorse it. Codification is a technical skill. Not every lawyer knows it. You take a judgment of a court which has endorsed a custom. You know, before any court will endorse a custom, that custom must not be repugnant to natural justice, equity, and good conscience, or public policy. So when the courts have ruled that this custom is okay, is good to go, then you, as the law reformer, you restate it in legislation. Legislature will now stamp it as a law. It becomes the customary laws of marriage of Benin Kingdom. So it's a very technical knowledge which not every lawyer possesses. So this is where as a law reform lawyer, you need to also have a good skill of drafting. Because when you take a judgment, the way judges write, judges do not write like legislative drafting lawyers. If you read the language of judgments, it's different. So when you take a judgment, you can't just take it and submit to the legislature. You have to restate it. That process is called restatement of customary law. In legislative language, you put it in legislative language, then you submit it to the legislature. They will pass it as a law. So that's a very technical process. The United Nations, they have a department which does codification of international laws, because every time the International Court of Justice passes a law, a judgment, it becomes law, but not automatically. There's a department called, what's it called now? There's a department of the UN. What's the name? I'll remember the name. Their job is to codify all judgments of the international courts. They will now put it in legislative language. The UN General Assembly will now pass it as a legislation. So these are technical things when it comes to law reform, law revision, law review. Law review is the preliminary. You review the law, all the laws of it, to identify which of them requires law revision or which of them requires law reform. So review is a preliminary step in the process. Then you decide which of the laws should go for revision or which of the laws should go for reform. Law revision, ideally, 5 years, every 5 years. Law reform, ideally, every 10 years. Codification, too, is something that the country will decide. How often should we codify our customary laws? Consolidation, too, is something, another exercise that needs to be done regularly. All the laws on children, you put it together. All the laws on taxation, you consolidate them. So these are technical languages. If you check the platform, I've put the publications on law reform, law revision. It's a place that you can focus your energy and learn a lot from. Ebenezer, are you there? Ebenezer.
Yes, I've been here from the time you started. Thank you, sir.
So you
Thank
continue.
you very much. We cannot thank you enough for this body of knowledge that you are getting at no cost. We implore every participant to take this thing seriously, even in a few uh, areas that legislative drafting is taught. It is taught theoretically what the books say, and when the tire meets the rock is practice. When you begin to practice, you now see gaps. If you are practicing, you will notice that what you were taught in law school, there are practical challenges, missing gap you were taught in law school because we taught theory. So when we are putting it to practice, you begin to see challenges that are not found in textbook. Now, what we are getting here is over 20 years of working on legislative drafting only as an area of practice. So, Prof, thank you very much, sir. Once again, we are going to go through the whole gamut of the we are going to go through the whole gamut of the content of today's, as we did yesterday. Prof has explained the subheadings, so we will not go to that again. Barring indexing and constitutional treatment. In fact, yesterday after the class, I had to go and look at the constitutional process of the Constitution of Ghana again. And I'm like, wow. Like I said yesterday, each constitution. Okay, Prof, you may proceed, sir.
No, I didn't raise my hand.
Okay. So each constitution has embedded in it the procedure of alteration. For Ghana Constitution, they have two, their constitution is divided into two main provisions. They have the entrenched provisions. The entrenched provisions are the provisions that are fundamental and foundational to the nationhood of Ghana. Their armed forces, their legislature, their executive, their judiciary, their independence, their police service, their human rights, all those national commissions on various things, all those, their territorial area, all those ones are entrenched provisions. And to alter any of those entrenched provisions, one, you bring a bill to the Senate, to the Parliament. Once that bill is read, first reading, that will be all. There will be no more progress on that alteration process until a referendum has been conducted in Ghana. This referendum will be conducted by the Ghanaian Electoral Commission, their own INEC equivalents, and not less than 40% of eligible voters should participate in that referendum. And again, out of the 40% that participated in that referendum, not less than 75% of them must vote in favor of the alteration. It is when this has happened that we can now come back to the Parliament to say, yes, the people have voted in favor of the alteration of this part of the Constitution. Then the alteration process will continue. And after the alteration process, their Constitution provides that at the end, the president shall sign, shall assent. So the president has no power of refusing assent or declining assent. Okay, Oren, your notice is noted. Thank you. Yes, Professor.
I want to take time to explain to you the drafting process when it comes to the Constitution. The reform, or the technical word for when you want to touch the Constitution is called alteration. Alteration. Now it may sound simple. Yo, I can do this. I'll just copy precedent. No, the process for altering the Constitution is different. And lack of knowledge of it is what is killing. Nigeria had the problem. Your country, Lesotho, also had the problem. I was invited by one of the lawyers to help advise the Attorney General then, 2021, because they couldn't understand the process. Even in the Gambia, I was in the Gambia January of 2021. The same problem, altering the constitution, lawyers could not know what steps. In Nigeria, 2000, and when Ekweremadu was chairman of Constitution Alteration Committee, he was sued for wasting 4 billion naira on constitution alteration. All the bills they drafted, the then president rejected them because they did not comply with the constitution. So it shows, and this is a committee that was surrounded by Gidado, SAN, professor of law, Amuchiazi, SAN, professor of law. The NGO sued them, instead of them to face the Nigerian constitution and see how alteration is done, they took 4 billion, went to Canada, say study tour. They want to see how Canada does their own alteration of the constitution. Meanwhile, the procedure in the Canadian constitution is different from the procedure in Nigeria. So why pay all that money to go to Canada? They were sued to refund that 4 billion naira. So the point we're making is, if you see the process, if you know the process, the current chairperson of the Committee on Constitution Alteration in the House of Reps is a lawyer, Benjamin Carlo. He said all the 31 proposals for state creation, none of them complied with the procedure in the Constitution for alteration of the Constitution. Because alteration of the Constitution to create a state requires that you go to the Surveyor General, you get a map, geological map of the new state you are intending, the coordinates. Coordinates means the boundaries. Before you now attach it and submit to the National Assembly, the legislature, you don't just sit in your office and draft a bill, say you want to create a state. So those procedures, lawyers do not take time. They just take money from clients and say, don't worry, we'll draft a bill to create a state. When you're altering a state, or the constitution to create a state, you have to amend the schedule to the constitution where we have 36 states. Because now by adding a state, you have to, that schedule will now be 37. It's no longer 36. So people don't know all these steps. They just dive in, take money from clients. Don't worry, we'll do it. Without this technical expertise. Constitution is another area of law. Even if you're a legislative drafter, when you're dealing with the Constitution, you should know that the rules of drafting, the rules of interpretation are different, so that you don't get it wrong. Carry on, Benito.
Thank you, Prof. So, you have seen it. I said it yesterday that every constitution has its own alteration procedure embedded in it. So, you have no business with a different jurisdiction or a different constitution in altering your own constitution. I was telling us the procedure for altering the Ghanaian constitution. Prof has mentioned the procedure for altering state creation. If your constitution alteration bill you are bringing borders on state creation, those things Prof mentioned must be part of the bill. If it is not part of it, the bill will be thrown away for non-compliance with constitutional procedure. The bill will be thrown away. So if you want to alter a constitution or draft a constitution alteration bill, the first thing you do is to get that particular constitution you want to alter. Go to its provision on constitution alteration. That is one. When you finish reading it, you find out whether there are specific sections that have different requirements. I mentioned to us yesterday, if you want to alter chapter 4 of the Nigerian Constitution, fundamental human rights, you require, in fact, firstly, if you want to alter the constitution itself, you require 4/5, 4/5 votes of members sitting, 4/5 votes of all the members, not members sitting and voting. All the members, 4/5 of all the members must vote in favor of that alteration. If you want to alter chapter 4 of the Constitution, you require the same number of votes. 4/5 of all the members must vote in favor of that alteration. And I say that this is a kind of vote you don't use voice vote. You cannot say those in favor of alteration of the constitution say hi, hi. Those against alteration of the constitution say nay, nay. The ayes have it. How do you determine by voice vote? Fourth, fifth, which is the number required by the constitution. So this is procedure. Two, if you now want to alter certain chapters or sections of the constitution, one is section 8, one is section 9, another is chapter 4. Anything you are doing around this, you require 4/5 votes of all the members. Note the difference. Not all the members sitting and voting. No. Of all the members of the House, because it is constitution, one, and that's what the constitution prescribes. Two, it is that certain provisions, certain sections of the constitution, like chapter 4, has been elevated above others within the constitution, or altering any other part of the constitution. While you still require the votes, but not 4/5, as regards chapter 4 particularly. Then when you are done with your constitution alteration process, you now require 3/4 votes of all the 36 states legislative House of Assembly to say, yes, we are in support. Now, the challenge I asked yesterday, Prof, we always use the word in an ideal situation. Our own case, is it ideal? Do the House of Reps, the state houses of assemblies, do they vote out of their own volition? Let's say Enugu State now wants to vote, and they want the constitution altered, or they don't want it altered. Does every member of the state have the liberty to cast his vote as he's convinced personally? That is a challenge, because what obtains most times is that it is what the governor wants. If the governor says, yes, we're in favor, our state wants it. Okay, gentlemen, please, let's vote in favor of it. It will favor our state. Okay, gentlemen, let's vote against it. If they do this, it's not going to favor our state. It's going to affect us here. It's going to affect us here. So you need 2/3. If you do not comply with this procedure, the courts will annul the entirety of the process as not conforming with the constitutional laid down procedure. Then we talked about indexing and gazetting. Okay, Prof, sir.
Now, as drafters, we don't just. That's why we say this purpose of this lecture is to elevate you from a mechanic to an automobile engineer. An automobile engineer knows the principle. Why are these things like this? Why is it that chapter 4 of the Constitution was the requirement is different from the other chapters? I mean, the other portions of the Constitution. The reason is the drafters, the lawmakers knew that human nature, we have the tendency to abuse or misuse certain things. Therefore, fundamental rights, which are critical for humans, should not be subject to easy manipulation, change. That is why the criteria is higher. The threshold is the drafting was made, the requirements higher. The same thing with section 188 of the Constitution. Anybody, because of the ongoing fighting in River State, I have become an expert in section 188. I've read all the history of all the impeachments in Nigeria. 6 governors have been impeached. 17 deputy governors have been impeached. Out of the 6 governors, the court said 4 of them did not meet the constitutional requirement. Out of 17 deputy governors, only 11 did not meet the constitutional requirement. The reason why the requirements under Section 188 are very stringent is to avoid the likelihood of abuse. Remember, power corrupts. Absolute power corrupts absolutely. So the drafters put checks on the power of the governor or the legislature to just impeach anybody. There were checks. That's why it's a long process. It's very rare to get any legislature that can meet all those steps. There may be one problem or the other. One of these checks is that it is the chief judge that will set up a panel to investigate the alleged gross misconduct. The reason is the legislature is the accuser. They shouldn't be the one to investigate. The chief judge, who is allegedly a neutral party, should be the one to investigate. So what do you learn from this as a drafter? If you are called upon, if you are involved in drafting of the Constitution, even ordinary legislation, whenever you confer powers on anybody, you must also create the checks on that power. If not, you are giving that person unlimited power, unlimited discretion. And what are you doing? Even if the person is an angel, when you confer too much power on somebody, you turn the person into a dictator. So these are things as a drafter. One of the things we learned when I was doing my PhD in drafting is how do you use drafting to solve or minimize corruption? One of the ways is to always check when you confer power, when you confer discretion, you do not confer absolute discretion. You create some checks, limits on that power by your drafting.
Thank you, Prof. Thank you, sir. So we look at indexing and gazetting. Prof has already discussed indexing. Indexing is basically the alphabetical the arrangement of laws of the state in alphabetical order for ease of access, for ease of reference. So if you are looking for, maybe you have 3-4 laws that start with M, one starts with MA, one starts with MI, one starts with ME, you already know that it should be MA. The next one will be ME. The next one will be MI. So it brings about order. You know where what is and how to get it without going to search left, right, center before you finally come back. Once you are looking for your laws, and that is part of the job of the Law Reform Commission, then for the National Assembly, the CNA does that for all the laws while he's doing his numbering. He also does the indexing. Then we said okay. Then we said that what's it called? Gazetting is the process of officially announcing to the public of the existence of a law, and this is done by the Attorney General of the Federation and AG of a state, relying on the authority of Igoro against University of Lagos. We discussed it last week when we were dealing with subsidiary legislation. The court rules that subsidiary legislation acquires the force of law when it is gazetted. If someone does not know about the existence of a law, can you charge him? Can you punish him? Can he run foul of that law? The answer is no. So when you draft, particularly at the local government level, ensure that that law is gazetted. That is when it acquires the force of law. We also talked about, when we discussed the lawmaking process, we discussed the last stage, which is presidential assent. And according to the Acts Authentication Act, the laws are supposed to be produced in triplicates, 3 copies on vellum paper. One is given to the office of the CJN for enrollment, the way you enroll your court order and judgments. 2, another copy is given to the CNA.
Ebenezer, what is CJN?
Sorry. Oh, what did I say?
I say, what is CJN? You have audience that do not know.
The Chief Justice of Nigeria. 1 copy is given to the Chief Justice of Nigeria. He is the highest judicial officer of the land. So, a copy is given to his office for enrollment. A copy is given to the CNA, the clerk to the National Assembly, for numbering and indexing. Then a copy is given to the Attorney General of the Federation for gazetting. I told us yesterday the process, the printer for the federal government does the printing, and the law is produced with official gazettes on it. That is the original copy of the law. If you are searching online, if you recall our lecture on use of ICT in legislative drafting and research principles, you will be searching. When you type a particular law, even the bill for that law, the proposal bill will come out. Then some other laws will come out. But you have to look for the one bearing gazette. That is the original and authentic copy. If you don't have the gazetted copy, you do not have a copy of the law. Prof told us a story here. They wanted to do a disability act, and when they were searching to see whether a law has been made passed in that regard, they stumbled upon a purported military decree online. And what happened? In the course of further research, it was discovered that the military never passed such decree. But some unscrupulous people packaged that together and hosted it online as if it was a decree passed by the military. And based on that, they used it to collect money from donor agencies to do NGO work. So you see that gazetting is important. If it is not gazetted, it is not the law. Now, as a drafter, even in your research, in your cross-referencing, ensure that you make use of the gazetted copy of the law. I also shared my experience earlier this year. The Supreme Court has new Supreme Court rules. So I placed an order for a copy. And the guy gave me a hard copy containing only Supreme Court rules for 5,000 naira. Then my colleague bought his copy, has attached to it other laws, including Notary Publics Act and all that. And I called the guy. I say, guy, why did you give me my own copy has only Supreme Court Act? Why did you not give me this other one that has other embellishments? And the guy responded and said, the one I gave to you was produced directly by the Supreme Court. It is the original copy. The other ones these people have are copies made by marketers. And to make it attractive, they have other laws and other rules attached to it so that if you are buying more. But there's a danger. There could be typographical errors, one. There could be omission of words in the course of trying to reproduce the original. They can make that mistake, and if you buy it, you buy their mistake. But the one I give to you is the copy produced directly by the Supreme Court. So in other words, he's giving me a gazetted copy, the one directly from the right source. So you need to know this as a drafter. Once you lay your hands on a law, the first thing you check is this a gazetted copy? Our constitution has gone through different alterations. We have the current one we are using now has the 5th alteration. But a lot of lawyers are not even aware of the implication and what it means. Some people are still using the 1999 constitution they used in the university, not knowing that that constitution no longer exists. So you will want to cite a session in court, or the court makes reference to a session, you open it, you are not seeing what the court is talking about in your session, because the copy you are holding is outdated, even though it is bearing 1999 constitution of the Federal Republic of Nigeria. So the latest and most current copy of the constitution is the one with the 5th alteration. So if you have a copy that has 1st to 4th alteration, you don't have the Nigerian constitution because it is not complete. How do you know this? Gazetting. As you're getting the constitution, you check, does this one have the 5th alteration? They will write it there, official with 5th alteration. That is how you know, okay, I have the original thing. So because you are a legislative drafter, if the premise of your draft is wrong, if the foundation law you are using to draft is wrong, it means everything you are doing is error. USA and McFord, you cannot place something on nothing and expect it to stand. If you are drafting relying on the 3rd alteration, the constitution with the 3rd alteration, and we are already having a 5th alteration, you will omit some things and you draft it. When it is queried, it will crumble. When it is tested, it will crumble. So we said in the context of legislative drafting, the law reform process involves identifying areas needing improvement, which is what Prof told us, conducting research, consulting with stakeholders, formulating recommendations, and ultimately proposing and implementing changes through legislation or policy, distinct from mere revision or consolidation. We already have seen the distinction between all these terminologies. Now we delve into the more details of the processes. Step 1, identification of issues and need for reform. Here you are doing law revision. And we say the law revision is the initial process of reviewing the law to identify whether it needs to be reformed or to be revised. Identification of issues and need for reform. One is problem identification. The process begins with identifying areas of the law that are outdated, ineffective, or causing unintended consequences. To do this, you have to read through the law carefully. You do not hazard a guess.
Hmm.
You do not hazard a guess. For you to
Okay.
know whether a particular session is outdated or ineffective, you have to read that session. So if
Hmm.
you want, hello, Mr. Obi,
Yes, sir.
you have a question, your mic is on, sir.
Okay. Sorry, I will have question, but not now. Or should I ask now?
Okay, you may ask now.
Okay, sir. Let me come. I'm trying to look at something like okay, correcting conflicting provisions in the same
Yes,
law
yes.
or in related laws. Is it revision or reform?
It is
That's one.
reform. It is
Okay, it's
reform
reform. Uh,
because you are going
okay.
to edit one
Okay. Uh,
sessions. That's called
okay.
any change in the substance of the law is reform, even
Okay.
if it's changing an to a.
Yeah. Okay. Okay. Let me also ask something. Today's topic on restatement. Is so
Yes,
beautiful. I have two books on restatement. Restatement of Customary Law in Nigeria, of Law of Nigeria by Niels, and an almanac of contemporary judicial restatements.
awesome.
I've been asking all along, what does it mean? In fact, some as a senior lawyer who was as confused as myself. Mm. Honored, very
Yeah,
confused. He didn't even pay attention to it. So today I
come to
very
understand
important.
what restatement is.
Yes, 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 yes. So either it is a judicial restatement or
That's
like
that
restatement of customary law.
judicial restatement. Who is the author? I have the other book, the one by Niles.
This one is by Tai Oshinto Kumbo Oshisonya. It's a 6 volume book. It's quite big. Is in about 6 or 7 volumes. Yes.
Which year is the publication?
It's the latest. Let me check because it's 2013, revised 2013. But there was an earlier one.
Okay.
The
And
latest is 2013.
he calls
Huh?
it judicial restatement of what?
Yes, an almanac of contemporary judicial restatements.
Okay. 1 minute.
Yes,
Okay.
with
Show me the cover. Show me the cover.
okay. Can I? How can I? Okay, will it show here? Is it like this? No, it's not. Let
Just
me
turn on
see.
your camera. Just turn on your camera and show the back of the book to the face of your camera. If you pick it.
My my camera on this Zoom.
Yes.
I'm trying
Just
to.
just turn your camera on.
Yes, the camera is only capturing only myself.
No,
It's not
because you have not. Maybe you turned it.
okay.
It's not on here.
Uh,
Yes. Open the camera. This thing icon on your phone.
okay, on my phone, which means I have to leave this place now.
No, you are not. Just where you are on this platform. If you check
Uh,
where your microphone is, beside
okay,
your microphone to the left is a camera icon but crossed, like cancelled. So if you click on it, your camera will come up.
okay. Let me
Yes,
see. What I have is
beautiful.
the
You can see
microphone
you
and
now. So you can now
huh?
show you see how Prof is holding his phone. So you can put the book like that. Just hold the book up in front of
But
your.
what I'm saying is that the camera, what I have video, microphone,
I
and
can see
one.
you now. We can
You can
see
see
you
it.
now. Yes.
Yes.
So raise the book up. Just show Prof the book. Just carry the book up to your face. We will see it.
Okay, something like this.
Exactly. Is it?
Okay.
Yes.
Yes. The smallest of the 6 or 7 volumes.
Okay. Each volume is a different book.
No, it's a set. Is one complete book in 6 volumes.
Okay. Wow.
Treating so many things. Yes. Oh, like this one I'm holding is a criminal, quasi-criminal law and procedure.
Okay. So where does the statement come in there?
Look at it is an almanac of contemporary judicial restatement. Well, that is what my confusion is.
Okay.
What they mean, can it be that using judicial statements as the new law in the subject?
Judicial statements into legislative languages, which is
Yeah.
and
But
now
this one is a private endeavor. I doubt whether it went to the to the legislature.
Sir?
This one is a private endeavor. It didn't. I doubt if it went to the legislature.
A restatement culminates in going to the legislature because you cannot pass a bill as an individual.
Yes.
When you get a judgment of court and you out of the judgment of court you formulate policy.
Okay.
Rather, you formulate bill, you turn it into a bill.
Yes.
The court will give order, some will be prohibitive, some will be declaratory.
Yes.
Do you understand? All those orders of courts has now formed the law via case law.
Yes.
To turn that case law into statute is where the restatement process comes in. Reading through that judgment, you reduce it into a bill.
Yes.
And forward it to the legislature. It goes through the lawmaking process that ends up with the presidential assent and it becomes a statute.
Yes. But
It's
apparently, even the one by now, apparently they didn't go through this process, but they still answer restatement. Why?
No, what you're having is a book.
Yes,
the book is the process of restatement, not the act itself, not the restatement itself. Yes, sir.
You know, you are attending this lecture. We said we are elevating our knowledge from mechanic to automobile engineer. That book you're holding, check the author. The author is, you know, there was a time this word restatement was sweeting in everybody's ear. They would just pick up the book, codification, without knowing what it really means. So this thing, that's the period when NIALS did their own. It's also 2013. So this book too, the author may have seen that NIALS book. Let me also do restatement.
Yes.
And they go and,
as you said,
without knowing what restatement means. Do you know? Now I've got the name. The United Nations has an organ called the International Law Commission. Okay. That commission is the commission that does restatement of all customary international law. Anytime there's a judgment of ICJ, they are the ones that will restate it as a law, send it to UN General Assembly for enactment.
Yeah.
Is made up of professors of law from each country, representative. Nigeria is represented by Elias Son. Elias Son is so good in international law that he's representing Nigeria and the United Kingdom at the same time.
Wow.
Yes. You know, his father was president of the International Court of Justice. So anytime there's any judgment on a novel area of international law, which has not been pronounced before, no law on that area, these experts, these legal experts, don't forget, some of them are civil law countries, some are common law countries. Their duty is to restate it as a law, send it to the UN General Assembly. Then those ones will now enact it.
Okay.
That's where the idea of restatement
came.
Mm.
Oh, thank you.
Please, sir,
Let
can you
me
state the
take
name
another.
again?
Can I?
Please, can you state the name again, sir? Please, sorry for interrupting. Of the commission you just spoke about.
National Law Commission.
International.
I didn't get it. I think it's the network. It's breaking.
National Law Commission
Okay,
International.
okay. Thank you, sir. Thank you.
is an organ of the UN that reinstates ICJ judgments into international customary codes.
Okay, Ebenezer, let me ask another thing. Is something that has been causing some controversy. Is 1999 Constitution of the Federal Republic of Nigeria, as amended, a correct usage?
The technical language is
Yeah.
as altered for legislative drafters. Even the
Yes. Okay.
Constitution itself uses the word alteration of the Constitution.
Okay.
The
So,
technical jargon as a legislative drafter is
yeah.
constitution alteration.
Okay.
But when
If
you come to court, you hear people citing as amended, 1999 Constitution as amended, as amended. Now,
yes.
you know the funniest thing? If you humbly want to correct somebody on
Yes.
that, the person will take you up on it and show you how many textbooks that have been writing as amended, and tell
Exactly.
you from its university days it has been as amended. Do you get it?
Yes.
And he will have more supporters of him than you. You will look like the fool. So my approach is that when I am talking, I say the 1999 Constitution has altered. Nobody has challenged me to say no, it should be as amended.
I have this experience to explain.
If you are reading text, you will see in brackets as amended. It is actually wrong. You don't amend, you amend other legislations, you alter the Constitution.
But somebody has also argued that you don't need to put alteration immediately on a, today is 18. If you say Constitution of the Federal Republic of Nigeria, what you mean is what that constitution is as today. There's no need to put altered. Is that? Have you noticed such a?
I have not seen that argument. I think it is a valid argument. However, we have not done, even on our constitution, a revision on it. One, we have not tidied the constitution. We are still having all those first alteration, second alteration, third, fourth, fifth in between. We have not had a clean copy of the constitution as it ought to be. So if the person is saying as, okay, Prof, sir, you have your hand up.
You know this plaque, they are well funded. They have a copy. I'll share it on the platform. The Constitution with all the 5 alterations. I'll share it.
Okay.
Thank you, sir.
Okay.
Thank you, sir. Thank you.
So if the person is saying 1999 Constitution as altered,
yes,
we are still using those alterations, but hopefully, you know, there's a constitution alteration that is ongoing now.
Yes.
Hopefully, when that process is completed and the Law Reform Commission becomes alive to their duty and responsibility, they might want to clean up the constitution and do a consolidation of all the alterations, and we now have one constitution.
Okay.
At that point, you can say the 1999 Constitution, or if we pass it as maybe 2025 Constitution now. Yes, Prof, sir.
I beg, don't raise people's hope with this law reform committee.
Haba, Prof, have you lost so much hope in Nigeria like this? Haba, we are.
Well, we are still hopeful. Things will turn out. Let me share one experience I have with. In fact, this one is with respect to citation. I was in an LLM class, taxation laws, and my teacher said Personal Income Tax Act. She said the ruling law on personal income tax was Personal Income Tax Act 2011. Say no, madam, it's not like that. What we don't use the Amendment Act to name a statute. It is the name of the principal act we use. She told me no. She had a PhD in taxation. What do I mean? Incidentally, before then, I had read a Professor Abiola's argument on this matter, where he said what we have is Personal Income Tax Act 2004. That's the principal act. And she was boasting that, but it was the person who actually supervised her, that is this Abiola Sani, who gave a paper on how to cite statutes that have been, or acts that have been amended. He said that it is the principal act you cite, not, you don't replace it with Amendment Act. Like in the case I gave, instead of saying Personal Income Tax Act of 2004, LFN, she said it is Personal Income Tax Act 2011.
No.
And every other person in the class kept quiet, like you did cite the other time. They seemed to support her view, and of course, she cited authority as per somebody who had a PhD. Unfortunately for her, it was her own teacher or her supervisor who taught me that the correct thing is to cite the principal act.
You know, some people are not, how do I put it, courageous to share or to tell people what they know. One.
Yeah.
Two, some people are so ignorant that they don't want to advertise it by opening their mouths. Because once they open their mouth, their level of knowledge will be revealed. So I think it is wisdom on the part of those who didn't talk by not talking, because they might not know that much. So it is safer for them to side with the lecturer and not incur her wrath than to go up and open their mouth and say the wrong thing. I think it is great wisdom. One. Two is approach too. Even when correcting, for me,
Yeah.
even when correcting, what is the intention? What's the motive? Are you correcting to ridicule this lecturer for people to know that he doesn't know? Or you are correcting with honest intention that this is the right way it should be done? I think some of the correction should be done in private. That's me, my thinking though. Prof.
Lesotho has just done the index of laws of Lesotho from 1800 to 2024.
I actually said my own in terms of question.
So
yes, I'm coming to you. Let Prof respond.
In their index, for each law, under each law, they tell you the date of amendments, the subsidiary legislation under that law. It's so tidy, makes everything look so tidy. This is what Nigerian Law Reform Commission should be doing. Instead of that, they are, you know what they are doing now? They amended their law to say they should have a state, a headquarters in each geopolitical zone, as if that will improve their work. Till today, no index of laws of the federation. So when you the process to keep the law books tidy, that's the work of law reform. That's why revision is every 5 years, because laws undergo amendments. you don't even know how many amendments are. That's why the National Assembly now says if you're bringing a law to amend an amendment, you should attach all the amendments to that law so that they know where they are. Because sometimes they amend a law twice without knowing. But this is the duty of the Law Reform Commission to create an index that shows how many amendments of that law have been has it undergone. Because the reason you keep track of amendments is when 60% of a law has been amended, then you repeal.
Okay.
Mr. Odu, your mic is on, sir. Thank you. Prof, you may
carry on, carry on.
Okay. So, gentlemen, we talked about identification of the needs and
we have gone far now. Tomorrow we continue. Today is
yes. I just want to complete that identification. Then we go for end the class today. So, what are we doing under identification? Problem identification. 1, review of existing law. 2, stakeholders engagement. So, at this juncture, we'll be coming to the end of today's class. Tomorrow, endeavor to join early. The class is always engaging and interesting, and that can only happen when you ask questions, when you participate, when you share your experience. So you are encouraged to do the 3. Thank you very much. Do have a stress-free day. Goodbye.